But it's very hard for most universities to operate without clear institutions and rules. And so starting in the late 1990s and early 2000s, many institutions of higher learning began to articulate policies to attempt to solve the same compelling interests that the University of California brought forth. And these policies were really a cornucopia. Everything was included in them. And because the court really didn't give a lot of clear guidance previously, a lot of these end up getting litigated. And so the two cases that we do going forward were handed down on the same day and originate from the same university. The university had two different policies depending upon what sort of system you were going into. And they go the opposite direction, one empowering the institution and the other saying that the institution can't do that because it's a violation of the Equal Protection Clause. So these two cases aren't the most current. There are more current cases, but I think these cases sort of very clearly articulate what the court is thinking about in terms of how affirmative action works going forward. And so the first case we're going to do is Grutter v. Bollinger in 2003. This case has to deal with the University of Michigan laws. God dang it. Starting over for the recording. This case has to deal with the University of Michigan Law School. And so the reason for wanting to take into account race and ethnicity were the same compelling interests that the court in Bakke said were compelling interests. This is a 5-4 decision written by Justice O'Connor. So since we know that the interests already are compelling, we can sort of put the interests aside and just evaluate the method by which the University of Michigan Law School took into account race and ethnicity in terms of admissions. So what were the list of things that the admissions committee were empowered to consider? You all should be exceedingly familiar with this list, as most of you, I think, are thinking about attending law school. So their considerations include the LSAT, GPA, letters of recommendation, personal statement, and an essay on how the applicant will contribute to the life and diversity of the law school. So there's the different requirement. Well, different in 2003, I think a little more common now. So this is a quote from the case: the policy requires admissions officials to look beyond grades and test scores to other criteria that are important to the law school's educational objectives. That includes a number of what we would call soft variables that are kind of difficult to quantify. That's why we call them soft. They're also very difficult to evaluate. Let me give you some examples. And this, by the way, should be considered advice in this regard. 1, the enthusiasm of the letter recommendator's writings. You all should consider not just the classes in which you got good grades, but choose the professors which you had a good relationship with, because one of the soft variables that most law schools consider is how enthusiastic the letter writer is about the candidate. So, an aside. Another soft variable that is considered, the quality of the undergraduate institution the student attended, the quality of the applicant's essay, the area and difficulty of the undergraduate course selection that the student had. all of those things are brought to bear in assessing an applicant's likely contributions to the intellectual and social life of the institution. So all of those things are soft variables which the university is empowered to consider. The admissions counselors at the University of Michigan Law were empowered to consider these things. The rule they have goes on. While admissions recognizes many possible bases for diversity admissions, it reaffirms the law school's longstanding commitment to racial and ethnic diversity, with special reference to the inclusion of students from groups that have been historically discriminated against, like African Americans, Hispanics, and Native Americans. So the admissions counselors or admissions committee was also empowered to consider the racial and ethnic diversity of its applicants. But it was included in a soft variable list that included things that were traditionally used to evaluate law school applicants, like quality of undergraduate institution and so on and so forth. So it was simply another thing that was added to the list for these admissions deciders to consider. It wasn't decisive in any way. It didn't, at least on paper, give anyone a clear advantage over similarly qualified individuals. It was simply another tool that this admission committee could use. So in this case, a white woman who had a GPA of 3.8 and a 161 LSAT score, I'll let you all consider that. I think most of us would probably kill for that level of qualifications. I know my GPA was nowhere near that high coming out of undergraduate. So this white woman with a 3.8 GPA and 161 LSAT was denied admissions to the University of Michigan Law School. That shouldn't be too shocking on its face, because the University of Michigan Law School is one of the most elite law schools in the United States. But even beyond that, she sued, claiming that the University of Michigan Law School's admissions policy violates equal protection and Title VI because it uses race as a, quote, predominant factor. Justice O'Connor, writing the majority opinion and the majority of the court in a 5-4 decision, so closely divided court, rules in favor of the University of Michigan Law School, so that the method by which they choose admissions is not a violation of equal protection or Title VI. Justice O'Connor, in her majority of opinion, discusses at length Justice Powell's decision in Bakke. There are sorry, I'm answering a question. You'll have to give me more than just that, Michael. I don't know exactly what you're referencing. I'll give you a second to type it, and I'll drink more water. Okay. Oh, yeah. How does it differ? It doesn't, until like the case gets decided, it's not clear that standard was promulgated in rules. So let me give you an example. So to describe everyone, there's a case rolling around through the courts that says Harvard's admission standards are too punitive on qualified Asian American applicants. That's going to be harder to prove. The reason for that is it has to be clear that there is systematic discrimination going on. Since Harvard is still admitting very qualified Asian American students, it's difficult to demonstrate that it is systematically discriminating against Asian American students. Does that make sense? Discrimination is really easy to identify if you just outright exclude a racial classification. So like Brown v. Board of Education, like no, we're like, oh, that's, yeah, you're not allowing African Americans, you have prohibited them. That's really easy to look at and identify. But in the Harvard case involving Asian Americans, it's much more difficult to identify the discrimination, or not identify it, but let me say legally demonstrate that there is discrimination going on, because it's not as though Harvard has stopped admitting Asian Americans. In fact, they admit many. And so it's going to be a much more difficult legal case to be proven. So jumping back to Justice O'Connor, Justice O'Connor talks at some length about Justice Powell's decision in Bakke, because she highlights that this fractured decision, her words, fractured decision in Bakke, has now become the sort of consensus majority opinion. So since the decision in Bakke, 78, till 2003, everyone kind of agrees that Justice Powell wrote a pretty decent decision. Now, O'Connor, it should be noted, was a clerk for Justice Powell. O'Connor at many times writes fondly of Justice Powell's decisions. But in this particularized case, she's actually stating a truth in that Justice Powell's decision has sort of become adopted as the means going forward. It's the majority viewpoint of the court, and she says as much. So she says quite clearly, we endorse Justice Powell's views that student body diversity is a compelling state interest that can justify the use of race in university admissions, and that this racial standard will survive strict scrutiny. Such classifications are constitutional only if they are narrowly tailored to further the compelling government interests. The law school's assertion that diversity was a compelling state interest is evidenced by the law school and many, many amicus who joined the case. Like an exceedingly large number of amicus joined the case, arguing in favor of university admissions practice. That includes education groups, business groups, military groups. Like it was a wide breadth of amici who joined the case. And the Supreme Court really relies on that amici to support the diversity being a compelling interest. The court argues that diversity promotes, quote, cross-racial understanding, helps break down stereotypes, and enables students to better understand persons of different races. These benefits are important and laudable because classroom discussion is livelier, more spirited, more enlightened, and interesting when students have the greatest possible variety of backgrounds. So it meets strict scrutiny, or so it meets the first standard of strict scrutiny, the compelling interest. But now we have to turn to the actual mechanism they used. She writes, to be narrowly tailored, a race-conscious admissions program cannot use a quota system. It cannot insulate a category of applicants with certain desired qualifications from competing with all other applicants. Instead, a university may consider race and ethnicity only as a plus in a particular applicant's file without insulating the individual from comparison with all other candidates for the available seats. Now, the plan in University of Michigan was that racial and ethnic diversity of a candidate was simply something to be considered in the file with everything else. Therefore, Justice O'Connor sees this as a very flexible goal, the very flexible tool. It's being used, as she terms it, a plus in a candidate. She argues that all underrepresented minority students have been deemed qualified. By virtue of our nation's struggle with racial inequality, such students are both likely to have experience of particular importance to law school's missions and less likely to be admitted in meaningful numbers on criteria that ignore those experiences. So, yeah, the system is absolutely okay. The University of Michigan Law School system, which considers race in the file as simply a plus, is absolutely okay under the 14th Amendment and under Article 6 of the Civil Rights Act of 1964. She's not done there, though. Justice O'Connor uses the majority opinion as a platform to sort of argue her opinion, which goes beyond the confines of the case just a little bit. She goes on to say that let me check time. Oh, okay, class is technically over. Okay, I'll finish this up. O'Connor, the United States advocates percentage plans recently adopted by public undergraduate institutions in Texas, Florida, and California to guarantee admissions to all students above a certain class rank threshold in every high school in the state. The United States does not, however, explain how such plans would work for graduate or professional schools, basically critiquing the government's position. Now, this case, and we're going to talk about the dissent, at least in part, before I log out, and I'll record the other one off. I'll record Gratz offline for you all. Justice Thomas concurs in part and dissents in part, and he writes a firebrand of an opinion. He starts with Frederick Douglass, speaking to a group of abolitionists almost 140 years ago, delivered a message lost on today's majority. I regard to the colored people that is always more than benevolent. I perceive that just manifested towards us. While what I ask for the Negro is not benevolence, nor pity, nor sympathy, but simply justice. The American people have always been anxious to know what they shall do with us. I have had but one answer from beginning: do nothing with us. So Justice Thomas agrees that there should not be distinct racial classifications. He agrees that the sort of quota system is absolutely unconstitutional. But he agrees that any sort of affirmative action system is constitutional. And so Justice Thomas's dissent is fairly powerful and persuasive, not just because of the least of the factors that Justice Thomas is an African-American writing passionately against affirmative action cases.